Thank you so much for the introduction. It's my pleasure to be here. And good morning, everyone. And thank you to Agre for that opening remarks as well. It's actually quite interesting that a lot of things are going on in Africa, and I'm happy that AfriP is also very interested to help SME on how to navigate through the IP strategies and benefit in Africa. It's quite a very good pleasure to be here this morning. My name is Tolu Olaloye. I'm a partner in the law firm of Jackson, Etsy, and Edu, and I'm going to be taking us in a training this morning, which is going to be on the impact of commercialization strategies and benefit for SME investing in Africa and measuring the effect of IP practices. By the end of this presentation, I believe that each of the participants listening to me this morning would have been able to understand intellectual property commercialization, understand the various methods of commercializing intellectual property, understand the importance and benefits of commercializing intellectual property, understand the importance and benefits of intellectual property commercialization, understand the essential considerations for EU businesses during the different stages of IP assets, understand various IP considerations and assets, commercialization, understand various IP considerations for the business practices such as the assignments, licensing, franchising, joint ventures within the African context, understand various strategies to address the main challenges of IP practices and commercialization in Africa and the key differences with the EU system, understand the importance of IP due diligence and the business benefit of IP assets commercialization based on case studies from EU-based firms in Africa. So at the end, we're going to be looking at all these principles, and I believe that you would have been able to understand that. So intellectual property commercialization. IP commercialization is the strategic endeavor of converting intangible intellectual assets. Intangible intellectual assets such as patents, inventions, trademarks, your logo, your name, your symbol, your brand, design, the ornamental angle to your inventions, copyright into tangible value in the marketplace. IP commercialization is the strategic endeavor of converting intangible intellectual assets like patents, trademarks, designs, copyright into tangible value in the marketplace. It also entails the expansion of economic interest through collaborative means into territories beyond the creator's markets. Simply put, that it entails driving financial benefit from your intellectual property. So when we're talking about IP commercialization, what should come to mind is, how do I gain? How do I gain from endeavoring to revenue from my intellectual property? And that intellectual property must have been patents, your inventions, your trademarks, your brand, your logo, your name that you're using for your business as an SME, your designs, your copyrights, and how do you bring all those things into the markets and make money from them? Now, the different stages or different ways in which you can monetize your IP. So first is that you must have identified that you have an intellectual property, you have an IP, and the different forms of IP, like I've mentioned, and then ways to monetize your intellectual property. And the different way to monetize your intellectual property is one, via an assignment. An assignment can be described as a procedure, a formal way as the direct sale of your IP rights. So when it's an assignment, it's an outright sale. You are selling it. So it involves the right of your IP rights from one entity to another. You are selling those rights to another person at an offer. So there is always a consideration for doing that. So you are making money from something that you've invented before. The second ways of monetizing your IP is franchise. And franchise is a business arrangement under which a party is allowed by an IP proprietor, you as the IP owner, to use a business model in exchange for a fee. So what the franchise or franchisee would get is a license to use a bundle of your own IP rights, such as your trademark, like the trade name, along with your processes, your business ideas, your business design, the goodwill of your business, of the proprietor, and then they use it at a fee. And the third way to monetize your IP, when we're talking about IP commercialization, is licensing. And licensing involves IP owners granting permission to others for the usage of their IP rights. So you are granting permission to another person to use your IP under predefined terms. So there are always terms for a license, and it's usually accompanied by fees and royalties. So this approach empowers IP owners to attain their ownership while concurrently sharing the risk with licensees. That's for licensing. And we also have the joint venture. The joint venture occurs where the IP owner, you as an SME IP owner, you then agree to enter into a business in consonance with each other, open to leverage on each other for combined benefits. So that is joint venture. So you both own the IP and you both own the asset, and you decide to go into a business venture using those IP rights in order to make money. Then we also have the spin-off. Spin-off refers to the process of forming a distinct independent firm entity from an existing organization. So you have an organization in existence, and to commercialize the intellectual property asset, you decide to establish a subsidiary that would focus its time, financial, human resources on the creation and management, commercialization of certain intellectual property assets. That's the joint venture. So these are so I believe that this is what IP commercialization is, and the different ways you can monetize your IP. And I've discussed the different forms. I've explained the different forms. And there are other forms or ways in which you can commercialize. And this also includes strategic alliances, where there's a collaborative cooperation between two or more businesses that aims to leverage their combined resources. So they come together, they form an alliance, they will have all those properties, resources, the IP rights, the patent. So it could be one company with a patent, another company with a brand, and then they come together to accomplish commercial goals. We also have the merchandising. This involves using a name or symbol, the distinctive sign for the purpose of selling goods or services. And in merchandising, we're going to be looking at a very good example is in sports. So when you have sport like Michael Jordan, what they do now with Nike. And then we also have the mergers and acquisition. This involves two companies merging together to become one big company. And they usually have a competitive edge in doing that. And we have the IP securitization. IP securitization is a financial strategy where intellectual property assets like patents, copyrights, or trademarks are packaged and sold as investment in order to raise capital or generate revenue. So intellectual property securitization is basically an asset themselves. So they serve as the IP becomes an asset, and they serve as collateral in order to raise revenue or more capital for the business. So what are the benefits of commercialization? We've talked about what IP commercialization is. We've talked about the different ways you can monetize your intellectual property assets and those methods that can be used and how you can use them to make money. Now we're going to be going into the benefits of commercialization. So what benefits would you as an SME company listening to this training this morning, what are the benefits involved? Number one is improved sales or profits. Licensing out your IP provides a source of revenue, helping companies fund further developments and growth. This increased profit aligns with the general benefits of an increase in sales or profit. So that's number one. So it helps you to have more revenue, because when you license how there's, like I said earlier on, there's taxes and there are royalties that you benefit from it. Number two, ways of benefiting from commercialization is brand expansion and image building, which I would also categorize as improved image. Licensing to reputable partners. When you have good partners, this can actually enhance a company's image and market position, which is in line with the general benefit of an improved image and capitalization growth. And a very good example of this would be Michael Jordan's earnings from Nike's licensing contract up to 2020. According to Centurion Global, having been around $1.3 billion. This figure is estimated to run up to 1.6 billion this year if you consider the boom in sneaker sales. That's a very good example of brand expansion and image building, and this is what commercialization of IP assets actually gives. Another one in assignment of future rights. So what do I mean by assignment of future right? It's a prospective copyright owner, usually an author. They can make an assignment of their future copyright in works that is not yet in existence at the time of the agreement. So by the time they are forming an agreement or an assignment agreement, the works is not yet in existence. But this will be useful for future purposes. And a very good example is where painting is commissioned or where a music publishing agreement is entered into before a songwriter creates the songs, right? So this is a good example of a benefit from an assignment of future rights. Would also have focus on companies' core competencies. What are the focus on the company's core competencies and how do you do this? So one of the benefits of commercialization is that by assigning your IP, a company can refocus their resources and effort on their core competencies and primary business objectives. So they then find out that, okay, so we are no longer doing these products, or we're no longer producing this, or we're no longer running this software again, we are moving to another software entirely. Then we have assigned that particular software to party B. And then in doing that, you can refocus or align the focus of your company, and they can leave the management, marketing, exploitation of the IP to a party that is better equipped to do so, allowing you to concentrate on what you can actually do best. Another one is rapid expansion. Once a company commercializes their intellectual property and assets, what you see is a rapid expansion. There is usually growth. And what do I mean by those growth? Franchising enables rapid expansion of a business with reduced capital investment and operation rates. A good example would be McDonald's. We see McDonald's everywhere, but it's actually a franchise. But you see them growing globally in different countries, in African countries, in Asia, in different continents. And the concepts align local entrepreneurs to operate and grow the brand. So what IP commercialization, one of the benefits is that there is always a rapid expansion. And you also have local expertise. The local expertise, franchises bring local knowledge, experts, enhancing the brand's ability to adapt to regional preferences and market conditions. Like Subway franchises, they often customize their menus to cater to local tastes in different countries, and thereby also showcasing the local taste. And the last one in terms of the benefits of commercialization is unlocking brand value. Unlocking brand value. Usually when there is a spin-off, it can unlock the hidden value of specific business unit or assets, which may not be fully reflected in the parent company stock price. When you look at eBay spin-off of PayPal, it resulted in increased shareholder value as the market recognized the potential of the two independent companies because you then have the PayPal and the eBay. So those are what IP commercialization gives to a company. And that is why it is a very, very important thing for an SME that's listening to me this morning to actually consider. So what are the important considerations for EU businesses venturing into IP asset commercialization? So what are the factors that EU businesses venturing into IP asset commercialization in Africa need to consider? One of the things to consider is you need to work with intellectual property practitioners that have a clear understanding of local IP laws and regulations. As you know that Africa is a huge continent, or we have 6 countries in Africa, so it's actually huge, and there are different laws and different IP laws and regulations within all these African countries. So it is very important that a common knowledge that IP rights are territorial. So such IP laws and acts and statutes vary from one country to the other. So what operates in Kenya is different from in Nigeria, in South Africa, and all those different African countries. So it's very important to have an IP practitioner that understands the African continent and that can help with the distinct law that regulates the commercialization of IP rights within their jurisdiction. So it's therefore important for EU businesses to engage legal practitioners in the target countries that will keep them appraised of specific legal framework that would apply to commercialization of their various IP assets, like government incentives, tax implications, CSR, draft contracts, draft agreements, such as license contract, partnership agreement, deed of assignment, lease assignment. All those things need to be done by a practitioner. So the first thing is for you to work with an IP legal practitioner that understands the different IP laws. Number 2 is intellectual property protection. So before you would venture into an IP asset commercialization, you must have protected your IP rights. Because it's when you protect the IP rights, you then have something you are bringing to the table. So the intellectual property, the trademark belongs to you, the mark, the patent belongs to you, the design belongs to you, the copyright is your own. Of course, you have automatic ownership for copyright, right? So you must have intellectual property protection. So as an EU business that is seeking to protect your IP asset in the African market, that's seeking to expand into the African market, it's very important that an assessment of the IP protection regime, which is readily available in the target countries, is very critical and crucial. So in Africa, it can be protected regionally because, like I said, that we have 56 countries, but we then have 2 regional filing system in Africa, which is the ARIPO and also the OAP. ARIPO is the English-speaking African countries that is made up of 22 member states. And these are Botswana, Eswatini, Gambia, Ghana, Kenya, Lesotho, Liberia, Malawi, Mozambique, Namibia, Rwanda, Sao Tome and Principe, Sierra Leone, Somalia, the Sudan, the United Republic of Tanzania, Uganda, Zambia, Zimbabwe, Cape Verde, Mauritius, and Seychelles. So under the ARIPO, so it confers protection in those states that you are designated, but the only thing is that in ARIPO, you must designate any of the countries of interest. The second regional filing system in Africa is OAPI. OAPI comprises of 17 member states. The Benin, Burkina Faso, Cameroon, Central African Republic, Chad, Comoros, Congo, Equatorial Guinea, Gabon, Guinea, Guinea-Bissau, Gabon, Ivory Coast, Mali, Mauritania, Niger, Senegal, and Togo. And all member states, they have automatic protection. So once you register with OAPI, you have automatic protection in these 70 states. So apart from this regional filing system, it's also very important to have a national filing in some countries that are not members of the states, like Nigeria, Ghana, South Africa. It's also very important that when you're looking at protecting your IP rights and understanding how to protect those intellectual property rights, you should also consider the custom recorders. Custom recorders are most of the African countries. We have what we regard as the custom recorders that allows you to register your IP with the custom, which can also help with the protection. Another one that you need to also consider is conduct market research. And what do I mean by this? The demand for IP in these countries, market trends in the countries, local competition, amongst others. So it's very important that you consider like local competition the consumer behavior, the market trends, the logistics of manufacturing and distribution and supply chains in these countries, the economic, political, and social stability of the target country or countries. Of the target countries or target country or country. It's very important. The economic, political, social stability, and it's also important to develop a well-thought market entry for these African countries. It's very important to have a well-thought market entry strategy that will consider your budgets, your timeline, and the resources of the business, so that the business would not just venture into it. Also, it's important to conduct local partnerships while collaborating with local businesses, partners that understand the local market and the regulations that can be invaluable. So they would aid in navigating the local bureaucracy, understand the cultural nuances. It will also help to conduct due diligence on local partners, agents, distributors to ensure that they have a reputable track record. So EU SMEs, they need to understand the nuances of each of this country with respect to local business requirements, legal framework, and repatriation of profits, because you want to invest in African countries, you want to bring your IP assets in this place, but you also want to be able to get your profit back in euros. So for example, in Nigeria, the royalties for trademark ranges between 0 to 0.5% of net sales, and is allowed strictly where the trademark is applied on goods that are locally manufactured. And for technical know-how agreements, the technology charge is often based on percentage of turnover that ranges between 0 and 5% of net sales, depending on the technology sophistication. And in the case of franchise, it's usually permissible to have a flat payment and franchise continue fee of 0.5% to 2% of net sales or income, and marketing and advertising 1% of net sales. So while parties can agree to a larger percentage in writing in the IP license agreement, they cannot register it with NOTAP. NOTAP is the organization that regulates the repatriation of profits through technology transfer. It's also very important that when you want to venture into IP asset commercialization in Africa, you need to consider the intellectual property enforcement. It's very vital to understand the local enforcement mechanism for IP protection. And many regions may have challenges in terms of IP enforcement. Some regions may have challenges, and that's why you need an IP practitioner who will help you out. And it's crucial to know, how do I protect my IP rights, or how do I enforce an infringement of my IP? Then also, in terms of dispute resolution, it's very important to determine the mechanism for dispute resolution, especially in most contracts, such as arbitration or local courts in case of conflicts, when conflicts arises. Now, we would be considering IP consideration for commercialization in Africa. What are the general considerations? IP consideration for commercialization in Africa is a broad issue. It's therefore important to understand the specific IP laws and regulations in each African country involved. And we are going to take case studies to see that in subsequent slides. In terms of general consideration, assignments must be properly documented. So when you have assignment agreement, it has to be properly documented, specifying the nature, the extent of the right that is assigned. The different African countries also have specific requirements for registering assignments, and compliance with this requirement is essential in order to establish the new owner's rights. And that's why it's important to know this and also align with them. In terms of license agreement, there must also be clear, comprehensive, specifying the scope of the license, territorial limitations, duration, and other vital matters. Licensing allows a business to grant permission to another party to use its IP. I think I've mentioned that in the earlier slide. So understanding local IP laws and regulations is crucial because licensing terms may vary between countries. So compliance with any compulsory licensing provisions or antitrust regulation is also important. It's also very important. Franchise agreement should be carefully drafted and outlined outline the terms and conditions of IP use, the fees, the supports, control measures to maintain brand consistency. That brand consistency is very important because franchise agreement should outline the terms and conditions of IP use, the fees, supports, the quality control measures to maintain brand consistency. Then we also have in joint ventures and spin-off. It is essential to clarify ownership. To clarify ownership, usage rights, responsibility related to IP asset in terms of forms of arrangements, and how would the IP be renewed. It's also crucial to assess the value and enforceability of IP from each other, as well as any potential risks or liabilities associated with it. Now we're going to be looking at different consideration for commercialization in Africa. And I'm going to be taking assignments case study for Nigeria. The intricacies of trademark assignment under the Nigerian law is beyond drafting the deed of assignment with respect to the assignment of a trademark in Nigeria. There are certain intricacies around the assignment of a trademark in Nigeria as provided under the Trademark Act of 1967, and that EU business considering, any EU business that is considering assignment as a commercialization strategy, they need to consider this. When you are assigning in Nigeria of a registered mark, can either be in connection with the goodwill of the business or without the goodwill of the business. Now, if it's with the goodwill of the business, it must be registered. If it's without the goodwill of the business, you will need to make an application to the registrar to inform them, and there will be an advertisement. Those are the processes that the IP practitioner will have to help you do. Also, in Nigeria, an unregistered mark is also assignable as long as it is done together with registered mark. Please note that assignment of a registered mark, you can only assign a registered mark. However, in Nigeria, the law makes provision of assigning an unregistered mark where it is done together in relation with the registered business, in respect of registered business, and it is in the same transaction. So for you to be able to register and be able to assign an unregistered trademark, it has to be done in the same transaction, and it has to also be done together with registered mark. So you can assign an unregistered mark on its own, but it can be done together with a registered mark. Now, upon finalizing the assignment and executing the deed of assignment, the assignee is required to register his title as well as the particulars of assignment together with the registrar of trademark. Where an instrument of transfer is recorded in the register, the same so it's also very important that the assignment is recorded in the register. Where the assignment is not recorded, the same is inadmissible in evidence in courts when you want to provide the title to a registered trademark, unless the courts otherwise direct. So usually it's always advisable that such assignment is recorded at the registry. In Kenya, in some African countries, there are certain tax implications that follow the means of assigning an IP. So in Kenya, for instance, where the IP is transferred by way of deed of assignment, nominal stamp duty would apply. However, where the IP is transferred by way of an instrument under the Movable Property Security Acts, the instrument of transfer would exempt from the stamp duty. And that's what operates in Kenya. Now we're going to be looking at the licensing case study. We've looked at assignment case study. We would also look at the licensing case study. And here we're going to be focusing on Ghana and Nigeria. In Nigeria, the National Office for Technology Acquisition and Promotion, which we call NOTA, is established capped royalty fee for services such as trademark, technical know-how agreement, franchise, and others. In terms of trademark royalty, payment for trademark ranges from 0 to 0.5% of net sales and is strictly permitted if and is strictly allowed where the trademark is applied on goods that are locally manufactured. So concerning the technical know-how agreement, the technology charges is often based on a percentage of turnover and ranges from 0 to 5% of net sales, depending on technology sophistication. In the case of a franchise, the following fees are permissible. The initial basic fee, franchise continuing fee of 0.5 to 2% of net sales income, or marketing advertising fee of 4% of net sales or revenue. Also, every contract or agreement that is not submitted for registration with NOTAP within 30 days of effective dates will be subject to 100,000 fine, and depending on the value of the agreement, that's for late submission penalty, which is 100,000. So therefore, it will be safe to comply with the threshold already set by NOTAP licenses or franchise when you want to do a license that deals with trademarks or technical know-how agreements. Now, in Ghana is almost like Nigeria. The position on royalty fees in Ghana is similar to the Nigeria because Ghana Investment Promotion Center, GIPC legislation, set out the threshold of fees payable under industrial property rights. This involved the assignment, sale, licensing of all forms of industrial property, patents, trademarks, trade names, or at 0 to 6% of net sales of transferee. Now, however, the Regulation 18 of the Technology Transfer Regulation of 1992 permit parties in restricted circumstances to apply to the Ghana Investment Promotion Center for increased fees to be paid by the transferee to the transferor. Therefore, where parties would like to contract at a very high fee, it's imperative that they make an application to the GIPC, where you make an application to approve such fee in order to avoid any penalties. Failure to comply with the registration requirements for trade-related transaction agreement is considered an offense according to Section 40 of the Act. So in such cases, enterprises found responsible may face penalties, including fines, potential additional sections upon summary conviction. Other business contracts, which we are also going to be looking at as consideration for commercialization in Africa, would also include non-disclosure agreements, NDAs. NDAs are usually used and very critical to protect confidential information exchange between parties. So enforceability of NDAs can vary from African countries, jurisdiction. So the drafting robust agreement is very essential, and in terms of what you include in those contracts. If you look at in the South Africa case of Tulip Diamond FZE versus Minister of Justice, Constitutional Development and others in South Africa, it's established when the court in South Africa would decide that an information is confidential and worthy of protection. So it's the court that will determine when the information is confidential and worthy of protection for the knowledge of third parties. So it further out in that case that it's not enough for the parties to define an information as confidential. No, the court must be able to examine the nature of the information and determine whether that information regarded by the aggrieved party as confidential has any sense of secrecy. Another consideration, IP consideration for commercialization in Africa is material transfer agreements. So the MTAs govern the transfer of materials containing IP, such as biological samples of research or data. This agreement should specify usage rights, ownership, and obligations. In South Africa, the South African Minister of Health has published a standard MTA. The notice mandates all South African research institutions sharing human biological material for health research or clinical trials to have a MTA in place based on the South Africa Material Transfer Agreement. This requirement also extends to parties outside South Africa. We also have the consortium. Consortiums in research or collaborative projects should outline IP ownership, the sharing, the management among the participating entities that want to use that form of agreement. And then the last one is consultancy agreements. When engaging consultant for business in Africa, it is essential to clearly define the ownership of the IP rights in the agreement, especially if any IP will be developed during the consultancy. So it's always very important to have that conversation and discuss who's going to own the IP rights at the period when the consultancy agreement is being taken place. Now, we've talked about IP commercialization. We've talked about how to monetize it. We've talked about the different method of protection that you have to also ensure that you put into consideration. We've talked about the benefits of IP commercialization. We've talked about the different IP constitutional agreement for commercialization in Africa. We're going to be looking at what are the challenges of IP practices and commercialization in Africa. Definitely, we have challenges. And we would also be looking at the key differences between Africa and the EU system as well. So that will be our next topic. Intellectual property practices and commercialization in Africa share common challenges with the global IP space, but some issues are particularly pronounced in Africa. So to navigate this system effectively, it is essential to seek guidance from an intellectual property expert who possesses a deep understanding of the unique nuances involving in protecting, managing, enforcing, and commercializing intellectual property in this region. The realm of IP practices and commercialization present a myriad of challenges, and it's imperative to engage an IP expert, which I've stated, and these experts are well equipped to navigate the complexities of the IP landscape. So imagine when you have 56 countries, definitely there'll be different complexity in all the states. And so that's why it's important that you should have an IP expert that would also help in order to navigate these challenges and these nuances. So some of the challenges basically include inadequate legal framework. And what do I mean by this? Many African countries have weak or outdated IP laws, and regulations are generally slow in implementing changes in the intellectual property landscape. The rate of development varies from country to country. We have seen some development. When we look at basic level of countries, in Somalia, trademark registration did not commence until 2019, after several years of closing down of the registry due to civil war. Currently, patent and industrial designs applications cannot be filed. They can only be recognized by publishing a cautionary notice in a local newspaper due to the lack of formal IP legislation in the country. Now, we'll also look at developing jurisdiction in Africa. In Nigeria, the Trademark Act dates back as far as 1969, while the 1965 Trademark Act in Nigeria dates back at 1965, while the Patent and Designs Act 1971 with little amendments. The Copyright, I would say that has really made a significant change of 1988, was recently amended and repealed by the Copyright Act 2022 in March 2023. The few amendments were also made very recently with the Nigerian trademarks through the Business Facilitation Act 2023, which then has enforced the service marks and some other additions. When we look at developed jurisdictions, countries like Kenya, South Africa have more proactive laws on intellectual property protection. Beyond trademarks, patent and designs law, Kenya has an anti-counterfeiting act number of number 13 of 2008 for Counterfeiting Acts, the Anti-Counterfeiting Coordination Regulation 2021 for custom regulator to enhance detection of counterfeit goods. That's in Kenya. Now, when we compare the inadequate legal frameworks of Africa to European Union has a strong, well-established, harmonized IP laws and regulation that provide a high level of protection for IPR. This consistency simplifies the process of protecting and enforcing IP rights in the EU. We'll also look at the enforcement issues. High level, even when IP laws exist in Africa, enforcement can be weak or inconsistent. This can lead to IP infringements, counterfeiting, and piracy, which undermine the value of IP assets and deter investments. To break it down, some of the specific issues encountered here would include no clear procedure for detection of counterfeits, compromise at port of entry. Dealing with established counterfeiting cartels can be very difficult. No clear computerized system recording counterfeiting activities and measures undertaken to curb these issues. Effective enforcement cannot be left to the authorities. That's why you need an effective IP practitioner expert. It has to be pushed by the IPR owner in collaboration with enforcement bodies, and do not forget, with an effective and efficient IP expert that can help you with the enforcement in that jurisdiction. When we compare that with European Union, the EU has mechanisms in place to enforce IP rights, including custom regulation that help prevent the importation of counterfeit goods, and courts in EU member states are generally well equipped to handle IP disputes. In terms of human resource and constraints and automation, many intellectual property offices in Africa, they have limited resources and funding, often operating with outdated technology system and insufficient staffing and experts. Many still operate with paper-based systems and have closed IP registers that require a formal search to access information, such information that you might need for you to make some business decision. So that's why you need an IP expert that understand the system and knows how the practice operates, so they can help in that regard. For instance, if you look at in Nigeria, IP registry is still operates in hybrid manner. So we have the online system in Nigeria. We also still have the IPAS system, which is the manual system, in terms of filing and registration through the online system. In Tanzania, trademark registry has gone almost fully automated in Tanzania and has started issuing certificates of registration, publication notices, conditional notices, exam records, and other post-registration certificates since 1st May 2023. Regional integration. So that's another way in which we could see some of the challenges that will also experience and the difficulty that are faced in commercialization in Africa. International collaboration and cooperation. African countries most times sign international treaties without domestication. And, without domestication, there is no enforceability. But in EU member states, they often engage in international collaborations and agreements that facilitate the protection and commercialization of IP assets on a global scale. And if you also look at how this thing operates in terms of regional integration, because of the disparities in IP laws and practices across most of the African regions, IP laws, in terms of the challenges we face, despite the presence of ARIPO and OAP, we call that we've discussed these two regional systems that operates in Africa, and it helps to actually harmonize some of these laws and helps to also enforce the IP regime and also to protect your IP commercialization. Registration in EU covers all EU countries and can apply for an EU, which covers the 27 countries of the EU system. But however, if you look at the regional integration in Africa, that is not the case, where we have 56 countries. So one of the regional filing, the ARIPO, covers 22 countries. The second one, the OAPI, covers 17 member states. So in ARIPO, a single application filed in ARIPO will give protection in member countries designated in the application. So you have to designate this. But it's also very important to have individual registration in countries that are not members of this regional filing system. And you also already know that your business has interest in these African countries. For instance, this country would include like Morocco, Tunisia, South Africa, Egypt, Nigeria, Somalia, and the rest of them. And that is also where we look at the international collaboration, that most times, I've already talked about the international collaboration, the domestication is always the issues. But in EU, there is already that international collaboration. So these are the different challenges of IP practices and commercialization in Africa. And it's important that we understand the challenges, because while we've talked about the benefits and how the IP commercialization in Africa is good for the EU businesses, it's also very essential that we understand the challenges, so that even when we are discussing with our IP practitioners and they are explaining these challenges to us, you have a foreknowledge of what it takes or what are the experiences that you might go through while coming into Africa for investment. Now, we're going to be looking at the case studies from EU-based firms in Africa, the importance of IP due diligence and the business benefit of IP assets, commercializations, and the lessons learned from these different countries. It's important to know that when we are looking at case study, before I go into this case study, with Africa having an importance, sorry. When we're looking at the case studies, it's very important for us to understand that with Africa having an enormous number of natural resources, and all the major European companies in mining as well as oil and gas are active in the continent. Major companies like Dutch Shell, French Total, Norwegian Statoil, Italian Eni, Spanish Repsol represent all in Africa. And they are tapping into the many recent oil and gas discovery made in Africa. So we can see Eni discovered major reserves in Mozambique, Egypt, and the coming year is planning to invest like 20 billion euros in Africa. And as for the mining companies, we also have the BH Building, the Rio Tinto, mainly in South Africa, and also Glencore are spread out over Africa with major copper mining of operation in Zambia, Democratic Republic of Congo. And we also have to trade all these commodities from Africa. Now, the question I'm sure you will be asking is, as an EU business, these are big conglomerates. How is this relevant to me? And why? It's very important because you can see that for Schneider Electric, they are not only does not have manufacturing facility in Egypt, they also have in Kenya and in South Africa. But it has also participated in many electrification projects. And how does this thing affect us? In terms of it's tried to know that this big conglomerate started from somewhere. And the protection and enforcement of the IP rights has helped them achieve major business goals today. So a lot of joint venture opportunities in Africa, and you as an SME business, it's company, you can also seize this opportunity either from first, you already protected your IP rights, and then you're looking at either an assignment, a license, joint venture, spin-off, merchandising, strategic alliances. You can also look at all those things and be able to make use of that in order to be able to expand your business into Africa. Now we're going to be looking at a major case study, apart from in oil and gas and mining, as I earlier introduced in this particular session for the case study. So we are looking at a Nokia as a case study today. Nokia in terms of technology, Nokia is a multinational telecommunication company based in Northern Europe, and it has been a prominent player in IP licensing. Nokia has invested more than 140 billion euro in research and development. The company has 20,000 patent families, including 5,500 that are deemed crucial to 5G connectivity. Nokia had sued Apple, alleging the iPhone infringed 10 of its patents, and in 2017, Nokia and Apple announced settlement of their intellectual property disputes, with Apple paying an upfront cash payment of approximately European euros of 1.7 billion. The two companies have now signed a cross-patent licensing pact, under which Nokia will provide Apple with certain network infrastructure products and services. Nokia's legal action against Apple highlighted the need for companies to diligently protect their IP assets. Furthermore, the subsequent settlements between Nokia and Apple underscores the substantial financial implications that can arise from IP disputes. So this significant payout emphasizes the potential of costs, because there's usually costs failing to address IP concerns proactively. And that's why, as earlier discussed, it's very important for you to always, at every point in time, face the IP concerns proactively, be proactive about it. The subsequent cross-patent licensing pacts between the two giants showcases the business benefit of IP assets commercialization. This agreement allows both companies to leverage their respective IP portfolios to access valuable technology, fostering innovation, potentially creating new revenue streams. The lessons from this is that the legal action against Apple highlighted the need for companies to protect their IP asset, and that's what I'm saying, that it's important to get an IP expert that would help you identify this, and also look at whichever IP commercialization options that you want to go for. And they'll be able to tell you the pros and cons, as earlier discussed in the session, which you would also go with them, or whatever agreement that you are going to put in place or sign in order to protect it. So, and that's why from our discussion today, we've looked at the IP commercialization, we've looked at the different forms of IP commercialization, the options, we've looked at how those options are available. We've also looked at what are the benefits of IP commercialization. We've also looked at the different IP considerations in Africa, and with some examples while we're talking about that. We've also looked at what are the challenges faced, because definitely there will be challenges faced, and we've also looked at case studies of conglomerate companies, and also we picked Nokia, and we also picked how is this relevant to you as an SME listening to me this morning. It's very important to know that the Nokia case study is relevant to you as an SME, because it will help you to diligently protect your IP asset. And because imagine if there was no settlement, that would have been a big loss to either of the parties. So based on this, I would like to say a very big thank you, and I'm open to question. Thank you very much.
Thank you very much, Tolu, for your presentation. It has been very interesting to hear from you about this subject. And before I open the floor to questions, I would like to add a comment regarding the fact that when you mention, for example, the lack of enforcement, or the fact that institutions can be sometimes weak, and therefore it can be complicated for European companies to register and enforce their IP rights when going to Africa. In that case, as you know, I am working for the EU IPO, the European Union Intellectual Property Office, and we implement a project that's called Afripi, and that it's actually working on behalf of the European Union because it's funded by the European Union to tackle these issues. So we cooperate with some of the organizations that you mentioned during your presentation, like OAPI and ARIPO, and we support them to strengthen the legislative frameworks, the institutions, and whatever we can do to improve the IP landscape across Africa. So this is part of our job, and we are really happy that we can contribute to improve these aspects. And regarding the IP SME Helpdesk, of course, it's an initiative that supports SMEs that are trying to invest in Africa. So all our efforts are towards the improvement of the system for the mutual benefits between European and African enterprises. So once again, thank you very much for your contribution. It was very inspiring and clear. I think that this presentation covered a very important subject. And now let me see if there is any question from participants. I remember that you can use either the chat or raise your hand if you want to ask a question to Tolu. Maybe to break the ice, I would like to ask you something about one of the most important aspects, let's say, regarding IP, that is enforcement, no? Because we mentioned that sometimes it's the lack of enforcement that can be an issue for companies that want to invest in Africa. So, for example, if you had to give one recommendation to a company, European company, SME, that would like to invest in Africa and that is aware that might be some issues at the moment of enforcing their IP rights, if there is any infringement, is there any recommendation you would give to them to avoid this aspect? I'm talking, for example, in relations to aspects on e-commerce or other aspects, especially when European companies are trying to enter in the market, like e-commerce could be one of the ways, no, to open business to bigger markets. But on the other hand, you can at the same time find your products being illegally sold or counterfeited online. So is there anything you would like to recommend on this side that as an IP attorney you would tell people to know or to do in this respect? Thank you.
Yeah, thank you very much, Andre. So in terms of enforcement, I would like to tell the SMEs, EU SMEs business to first protect your IP, have a good registration, and then in terms of infringement, you have to basically have a watch service being done for your marks or your patents in order to be able to find out if there's anyone infringing on it, and also take opportunity with the African countries that has custom recorders. That is also very effective. I've seen it very effective in Kenya. So when you register with them, if there's anyone that's bringing in a product that is similar to yours, at the point of entry, that can also be detected. So we have some of those African countries that are started doing the custom recorders. So this is something that would also help. Another one that could very, very help, I've seen worked, is injunctions against the infringed parties. So this is something that can also, I've seen worked out for rare instances where companies' rights have been infringed upon. So you can also have that injunction being done. And once you have a registered mark or registered patent, it's very easy for you to be able to then institute an infringement actions. And where there's no registration, for you to be able to do a person of action, you must also be able to prove all the three, tick all the 3 points that it's affecting your business and is well known and all that. So those are the things I would say. And also, when IP experts are giving you some recommendation, just try and follow the recommendation immediately, because we've seen instances where by means of watch service, they've mentioned this to businesses, or that there's somebody that is trying to infringe on your rights and all that, but you just feel that, oh, we have no business interest in Kenya for now, or we have no business interest in in Cameroon for now, so it's no issue. And maybe in like 3-5 years time, the business then realized that they need to go into Kenya or they need to go into Cameroon. But because of the small issue that was not taking over at that point, like 3 years ago, by the time you're going into Kenya in 5 or 3 years time, it's already a big issue, because guess what? The person has been using your brand and have been using it to strive, monetizing or using that thing. So it's always very difficult in that instance. And then you find yourself in court action where the business is not at risk in terms of money to be used. So what I would say is that at every point where you have any information on how to actually protect your IP in terms of responsibility, please just take initiative or take that opportunity at that point in time. Do not let it slide. Do not let it slide, because when it slides, it creates a bigger problem in terms of enforcement.
Thank you very much, Tolu. It's clear. It's clear and very useful to know. This actually leads me to another question that you also mentioned during your presentation regarding alternative dispute resolutions. For example, if something happens, do you have any experience of successful cases where you could solve the issue without going to court? That sometimes we know that can be lengthy and costly procedure. So if you have any advice on this matter also, that would be also interesting to know.
Okay, very good. Okay, so in terms of alternative dispute resolution, we've seen like 2, 3, not even, I think more than 2 instances where it has been successful. We've done a lot of quite a number of alternative dispute resolution for parties. And very recently, the WIPO also have collaboration with Copyright Commission in Nigeria. That's an example of alternative dispute resolution. And in practice, we have seen instances where parties do not want to go to court and they settle out of court. And especially where there is a provision for alternative dispute resolution in the agreement, it makes that very easy for us to be able to enforce. Because if there's a provision for alternative dispute resolution in the agreement, it makes it easy for us to be able to enforce, and that will be the first point of contact before going to court, and then court will be the last resort, because we all know the intricacies that goes in court. So most time, because of the business, people decide to go into alternative dispute resolution, and there's been a lot of awareness in terms of dispute mechanism for IP in Africa generally.
Okay, thank you very much.
Yeah.
I think we have one question in the chat that I can. Yes, I can see that Didier Mpore from Rwanda is asking something regarding if there is a way to measure quantitatively the influence of IP practice on commercial success of an SME, especially investing in Africa. This is a very detailed question. I don't know if there is a way to quantify exactly, but maybe Tolu, you would like also to complement or to answer to this one.
Okay, thank you very much, Dida, for that question. And your question is, what are the key metrics for measuring the impacts of IP practices on SMEs' commercial success? I think number one key metric that you would see is in terms of revenue. How the business has fared in the year. So, and that will be in terms of the income made, one. Number two would be also be in terms of your royalties, because when you are looking at the IP commercialization success, you are looking at a situation where you are considering what your IP rights is. So when there's a license, in terms of the royalty that is being paid for you for somebody using your IP rights. So if the license royalty says that you are getting that income in every 2 months or every 3 years, and you're no longer using that, so you know that for in this quarter, maybe 200,000 euros is coming in from the fact that somebody else is using your IP rights. So that's another great impact for IP commercialization of your intellectual property asset that are seen. And usually, how can we quantitatively measure the influence of IP practice on commercialization of success investing in Africa? I think number one is in terms of franchise. You will see that's a term franchise. So what we can also see that a lot of individual companies are bringing brands into Africa, and then they're using that one to increase the brand visibility and also to sell the products. Another great one is in terms of licensing, and then spin-off. Spin-off has also helped, because when you see that a particular part of your IP is not what you are using again, but you want to use it to set it off, and then it starts on its own, and then you see how that subsidiary is growing and is making revenue or profit. And because of the fact that maybe in terms of marketing, your advertising, you already have another company in Africa that could be doing that for you, and they are paying you for doing that. I think those are the places where we have seen successes for using your commercialization of IP assets. And I believe that I hope I've been able to answer that question.
Thank you, Tolu. I think we have one last question we can take because we are over the time, but maybe if you would like to take this last one from Didier.
Okay, so can you provide specific examples of SME that have effectively used IP practices to achieve success in African markets? Okay, so because of confidentiality's sake, I might not be able to specifically mention names, right? Because of course there's always confidential agreement between attorneys and business owner. But I can tell you that I have seen license, and that license with respect to technology. And what that IP commissioner did for them was that they were able to repatriate their profit away from Nigeria using the NOTAP. That's the National Office for Technology and Promotion Center. So they came in, they used the license their technology, they licensed it to a company in Nigeria, and at every point in time, they were able to take the funds away at the rate of the federal government, which is CBN rates, which is like, it's always a difficult tax for most SME, because by the time you want to take your profit back away from the country, it's usually maybe the market value. But if you are registered with NOTAP, you'll be able to get the federal government market value. So I've seen that in existence, and it has worked out for that client.
Thank you, Tolu, very much for your answers. Very comprehensive, and but I'm afraid that we don't have more time today, because we spend almost more than half an hour more than foreseen. So I would like to thank you very much for your time today. I shared in the chat the survey, the satisfaction survey that you can open, and you can also, of course, mention your opinion. And if you have any suggestion for topics in the future, you can take them into account for future webinars and events. So once again, thank you very much for your time today. And if you want to follow more of our activities, of course, I said that we have plenty in our website available. You can simply register, and as we did today, you are welcome to join. So thank you very much for your time, and see you soon in another occasion. And thanks again to Tolu for her excellent presentation and for her time today. It was very appreciated from our side. Thank you.
Thank you. Thank you very much, Andre. Thank you, everyone. Thank you for having me. Do enjoy the rest of your day.
Thank you.
Thank you to the organizers. Thank you.
Have a good day. Bye-bye.